As a prosecutor, I am required to evaluate the available evidence and determine whether or not there is enough evidence to proceed with a criminal case. The criminal case for this event would be the decision as to whether or not to charge her with a crime of manslaughter. Manslaughter is, in Maine law, it's in the criminal code. It's not a specific motor vehicle offense. It is defined in the exact same way that manslaughter would be if it was committed with a knife or a gun or with fists or in a fight or something like that. It's defined as recklessly or with criminal negligence causing the death of another human being. Because of the serious injuries to Mr. Coggeshall, there's another crime that could be charged, which is the crime called aggravated driving to endanger, which is committed if a person with criminal negligence, again, so it's the same definition that applies in manslaughter, causes serious bodily injury to another person while operating a motor vehicle. Those are the two crimes that would be charged if there was enough evidence to charge Cheryl Torgerson. My conclusion, based on the evidence that the officers uncovered, was that there was not enough evidence to show that she operated with criminal negligence, meaning that she had a state of mind that makes her guilty of criminal behavior as opposed to responsible for damage or destruction in the civil sense. Which I guess leads me to sort of the broader question. In deciding whether or not the operation of a vehicle is a crime or not, we're looking really at a continuum from one end to the other. At one end are cases which are absolutely, totally clear to be manslaughter. Somebody who gets intoxicated or impaired by drugs, or who drives at 100 miles an hour, or who tries to outrun a police cruiser in a chase. Those kind of circumstances, if there's a crash and somebody dies, would very likely be charged as manslaughter, along with maybe a host of other crimes as well. You might say at the other end of the spectrum are situations where, and I never really like to call it act of God or pure accident, because there's always some human responsibility, but you can certainly envision situations where a person who's driving down the road in the late spring on an unfamiliar road goes through a dark, a patch where the sun doesn't shine, and it turns out that there's some ice there that hasn't melted. No other road in the area has ice except that one section, and they lose control and crash, and a person is killed. That's the kind of thing. It's so hard to anticipate for anybody that I think it would be impossible for anybody to say that's manslaughter, even if a person dies. Even if a horrible result occurs, the driver's behavior is not at a level where you can say that they're guilty of criminal behavior. So if you say that that's sort of one end of the spectrum, and the drunk or the high-speed person that's the other end of the spectrum, then there's everything that's in between that. And the question is, does it belong closer to this end of the spectrum with a drunk with 100 mile an hour or the high-speed chase, or does it belong at this end of the spectrum? And that's a question that prosecutors have to grapple with several times a year in this state, around the state. So when I looked at the events of August 11th, that's what I'm asked to do. What I'm required to do as a prosecutor is try to decide where it fits on that continuum, and specifically whether we can prove in a criminal case, which means beyond a reasonable doubt, and if any of you have ever sat as a juror in a criminal case in this county or any other county, you would have been told by a judge that's the burden of proof for the state in a criminal case, beyond a reasonable doubt, that the death of Dylan Gold was a result of the criminally negligent driving behavior of Cheryl Torgerson. And my conclusion was that we could not prove that beyond a reasonable doubt, and therefore the case should not go forward.